Welcome to our overview of Chapter 10, Tort Law and Other Liability Issues. Tort law is civil law recognizing the plaintiff's legal right to just compensation for damages caused by the defendant. The roots of U.S. tort law can be traced back through English common law, early Germanic law, Roman law, and the law of the Torah. A system of tort law is a necessary foundation for any civil society. The main functions of tort law are to provide 1. A lawful means of obtaining just compensation for damages, and 2. A deterrent against future injurious conduct. If citizens could not turn to the courts in tort law to seek just compensation for injuries caused by the wrongful acts and negligence of others, many would take the law into their own hands, resulting in additional unnecessary conflict, injury, and an ensuing cycle of retribution in the community. Further, while most people are generally honest and responsible, those that are not are far more likely to conduct themselves honestly and responsibly if they know they will be held financially accountable under tort law for the harms caused by their wrongful or negligent actions. Because tort law plays an essential role in helping to maintain civil order, tort law developed as civilization developed, serving as a basis for just compensation and as a deterrent against injurious conduct. As societies increased in size and complexity, the importance of tort law increased as well. Functional civilizations require mutual interreliance and fundamental trust among citizens. In modern societies, however, with millions of interreliant citizens, individuals cannot know everyone they rely on by name and reputation as they once did in small communities. Nonetheless, citizens must be able to maintain sufficient trust in others, or the social and economic systems stall and collapse. Modern life requires cars, elevators, supermarkets, restaurants, medical care, etc., and reliance on other people to produce, deliver, and maintain needed goods and services safely and responsibly. Imagine a world in which no product or service provider had any responsibility for the damages or injuries they caused. You could have no realistic faith that the brakes on your car were safe, elevators wouldn't fall to the ground, food was safely produced, refrigerated, and cooked, medicine was safe, doctors were qualified and conscientious, etc. Without consequences for wrongful and negligent acts, there would be far more wrongful and negligent acts and far less social and economic trust. Under such conditions, the social contract and civil society itself would quickly begin to unravel, causing immense harm to all. Tort law is the means of enforcing the necessary social contract of mutual responsible conduct. The compensatory role of tort law acts like the remedial function of contract law, and the deterrent role of tort law acts similar to the deterrent effect of criminal law. The result is, through a just system of tort law, mutual trust is increased, irresponsible conduct is discouraged, and the risks and costs of injuries can be more fairly distributed consistent with rational public policy. No system is perfect, however, and most everyone has heard horror stories of extreme tort law claims and damage awards. Your chances of falling victim to an unjust tort claim, however, can be greatly reduced if you understand the tort law system and use common sense and prudent preventive measures to avoid unnecessary risks, injuries, and liability. This chapter explains the essential principles of tort law and other relevant liability issues in educational institutions. Regarding tort law generally, the law of torts and contracts are similar, but the tort contract is an implied social contract to act reasonably in interactions with others. If you have a legal duty to others, there is also the implied social contractual obligation of acting reasonably in fulfilling that duty. The civil society offers citizens an opportunity to participate, and persons accept this general social contract by participating in society. Individuals may also assume higher duties of care by choosing to participate in activities that have a higher potential to harm others if reasonable care is not exercised. For example, all members of the common society have a general duty to refrain from harming others. But if someone chooses to engage in potentially dangerous activities, like the use of power equipment, vehicles, chemicals, etc., creating possible risks to others, special care is required, and there is a higher duty to protect others from foreseeable harms. Persons offering professional services also acquire a higher duty to provide those services consistent with the standards of practice and professional ethics adopted by their profession. In Chapter 10, we will review tort law generally, tort law negligence claims, possible defenses to negligence claims, constitutional torts, and 42 U.S.C. Section 1983, educational malpractice, defamation, intentional torts, assault and battery, false imprisonment, invasion of privacy, intentional infliction of emotional distress, and other important areas of safety, concern, and potential liability, including child supervision, personnel supervision, school visitors, school activities, buildings and grounds, health and safety hazards, emergency planning and response, information security, compliance with state and local laws, insurance and risk management, and copyright and liability. In summary, teachers have a general duty to instruct, supervise, and protect children from known or reasonably foreseeable dangers. School officials have a duty to reasonably supervise employees and students to keep school property safe and to protect against or warn of any known or reasonably foreseeable dangers to students, faculty, staff, or visitors. Recognizing and reasonably addressing potential problems before they become emergencies is the key to safety and liability management. It is per se negligence to leave children unsupervised. A responsible adult must be in charge at all times, supervising children from the moment school officials take physical custody until custody is transferred back to the parent. School officials are responsible for reasonably supervising on-duty personnel and may be held liable for negligent supervision and on-the-duty tortious acts of employees under the doctrine of respondeat superior. School officials have a legal duty to supervise and control public school buildings and grounds. To enhance safety and avoid liability, buildings and grounds should be regularly inspected, identifying and correcting any security and safety hazards. Safety equipment and procedures must comply with current standards of practice accepted in the field. School officials must comply with federal and state laws concerning hazardous materials, storage of and use of chemicals, and any other significant environmental, biological, or other known hazards. Consistent with federal and state laws and local ordinances, school officials must have an emergency management plan ready to respond to the dangers most likely in their areas, such as tornadoes, earthquakes, wildfires, flooding, hazardous materials, etc. Regarding personal information, school officials have a duty to keep confidential information protected. School computer systems must be adequately protected to secure information, and school internet systems must be operated with a filtering system in compliance with the Children's Internet Protection Act. Copyrighted works that are within fair use may be lawfully copied and used for educational and other lawful purposes permitted by the U.S. copyright statute. Otherwise, copyrighted works require lawful purchase or permission. In conclusion, regarding the required duty of care, tort law requires conduct consistent with what a reasonable person would do under the circumstances. When in doubt, err in favor of greater care. Tort law legal duties are only breached by falling below the ordinary standard of care. Exercising extra care protects safety and prevents liability. Regarding safety planning and prevention, in the areas of safety and liability, an ounce of prevention can be worth many pounds of cure. Prevention is the key to protecting safety and avoiding liability. Time and resources spent now on wise planning and prevention efforts will ultimately save time and resources in the future. Look for potential dangers and correct them before they become emergencies. Walk your buildings and grounds thinking about what could happen and take action now before it does and injuries result. Pay special attention to children's play areas. Each year, over 200,000 U.S. children are sent to emergency rooms for playground injuries. A third of these are classified as severe, and at least 15 children die each year due to playground injuries, mostly from falls on hard surfaces and suffocation due to entanglement or head entrapment. Inspect your entire school for safety, and especially playgrounds, parking lots, and other high-risk areas for children. Be sure and look at locations and activities from not just your perspective as an adult, but also from the perspective of a child, to see potential dangers that might otherwise be missed. By making prevention a priority, you will not only save time and resources in the future, but you may also save lives. Regarding professional, respectful, and fair treatment of all persons, accidents and errors are inevitable, but tort suits are not. It is unnecessary and unwise to admit negligence on behalf of the institution, directly saying, for example, "It was completely our fault, we should have been more careful." But it is humane and wise to express sincere concern regarding any accident or error, and to offer to help to the degree possible, saying instead, for example, "I'm very sorry that happened. Let's see what we can do to help," which is professional, respectful, and fair, without admitting negligence on behalf of the institution, which educators are generally not authorized to do, but could cause serious problems in any future litigation. Legal fault, and whether school officials were in fact negligent, can be complex legal questions that may be litigated later in a court of law. A voluntary admission of negligence on behalf of yourself and the institution is not a necessary part of treating a mishap sufferer and potential future plaintiff respectfully, humanely, and fairly after an incident. But kindness, genuine human concern, and an offer to help when possible are always appropriate under unfortunate circumstances. Further, persons treated professionally, respectfully, and fairly by school officials are generally less likely to become plaintiffs than persons further angered by unprofessional, disrespectful, and unfair treatment after an unfortunate incident. The most important part of learning about tort law and avoiding liability is becoming far more focused on accident prevention and everyone's safety in schools. Protecting the safety of all persons is a core mission for institutional leaders. Make this a top priority for you, and you may be able to not only avoid liability, but also avoid unnecessary injuries and even save lives. I hope that you will enjoy your studies. Very best wishes to all.